All rise. Court of Appeal Division 1 is now in session.
Good morning. Please be seated. All right. We are here now for oral argument in CV22 0271 Jones versus the Center for Orthopedic and Research Excellence et al. As you may know, we are recording and currently live streaming this argument, so when you rise, please give your name and the name of your client for the benefit of the audience. You each have a maximum of 20 minutes per side, as is reflected on the podium. You are not required to use all of that time, although you are welcome to do so. If you would like to reserve some time for rebuttal, that's up to you to maintain your time. Please keep in mind we have read your briefs, we've studied the record, we've discussed this case in conference this morning, and with that, please proceed.
Good morning, and may it please the court. My name is David Bray. I'm with the Dickinson Wright Law Firm, and I represent Dr. Clifford Jones. This court should reverse the ruling below because Section 6.2 of the contribution agreement is an unreasonably overbroad physician non-compete covenant that's contrary to the Arizona Supreme Court's Farber decision and contrary to Arizona public policy.
Counsel, before we get too far down the road, I wanted to ask you a couple of questions about the Superior Court's ruling. The Superior Court didn't reach any findings of fact, at least in the written ruling. So two questions about that. The first is, are you contending to us that there are disputes of material fact, or just that the court erred on the law?
Sure. My alternate argument, Judge Perkins, is that the trial court put the cart before the horse in its ruling. The trial court made no determination as to the reasonableness of Section 6.2 of the contribution agreement, which is called, quote-unquote, restriction on competition. The only thing the trial court did was found that Section 6.5, which is the liquidated damages provision, is, quote, enforceable as to Dr. Jones. So we believe that under the governing case law of Farber, the non-compete restriction in Section 6.2 is unreasonably overbroad.
Didn't the court explicitly find that 6.2 section was also enforceable?
Not in its minute entry, Your Honor. If you look at it, the only thing the court says, it lays out the summary judgment standards. It says Section 6.5 is as enforceable as to Dr. Jones, $240,000 in liquidated damages.
Do we need to presume that as part of the court's ruling that it found reasonableness, given that that is the test for these types of non-competes? I'm
not aware of another case where a trial court took the what's called a factually intensive inquiry that's supposed to be done on a case-by-case basis as to a non-compete and then issued a ruling just on the liquidated damages clause. So if that's what the trial court did, I think the trial court was wrong. I think there are issues of fact as to the reasonableness of the Section 6.2. But as I said before, I believe in this case that Section 6.2 is facially unreasonable. But certainly the trial court didn't make any findings of fact. The trial court seemed to think that because there is a sum certain in Section 6.5, I don't have to look at Section 6.2. That's what I think the trial court did.
So last clarification point, your argument to us is that as a matter of law, we could flip this and enter judgment, but if we are not willing to do that, then you think there are issues of fact that need to go back.
Exactly,
do I have that correct?
Your Honor.
Okay.
Yeah.
And I want to follow up from that question and Judge Perkins' original question. I get that you're saying the court didn't find reasonableness, but what are the disputed facts that would need to be resolved in order to determine reasonableness? Because I read reasonableness as a question of law based upon the facts underlying it.
Yeah, I think in the non-compete context, the question of reasonableness is a mixed question of fact and law. Ultimately, it is a question of law. I just had a trial last July dealing with a restrictive covenant where there was a jury instruction applied where they allowed the jury to be the trier of fact for whether a non-compete
was... Is it trier or trier?
Trier of fact.
Oh, okay.
Sorry.
Sometimes I learn new things, and I thought maybe I'd been mispronouncing that my whole life.
Yes, I believe a lot of the facts are undisputed. I believe there would be additional facts that could be explored, like, for instance, the whether there was a shortage of orthopedic surgeons, further development of the facts regarding COVID. One of the things I was going to mention was the restricted period in this case included those months in 2020 when Governor Ducey's executive order was in effect that barred all elective surgeries.
But when you presented your cases to the Superior Court, were there disputed facts? Did you guys argue about A or B, or did you kind of submit it on a somewhat of a stipulated record of here's what the agreement provides and decide this for us?
Sure, I believe each side did. There were dueling motions for summary judgment.
Right.
And each side did, statement of facts. And I think some of their facts were controverted and some of our facts are controverted. I tend to agree with you, Judge Morris, that the majority of the facts in this case are uncontroverted. But
And the material facts, is there a material fact that you could point me to today that would say it would preclude either summary judgment for them or summary judgment for you?
Sure, I don't think there was an exploration of the impact of the non-compete on patients in this case. I don't think there was an exploration of the impact of the non-compete on the provision of medicine and emergency services and orthopedic surgery during the COVID pandemic.
Okay.
One of the things I wanted to mention was that the restricted period in this case included those months in 2020 where Governor Ducey's executive order barring elective surgeries was happening. And during that time, during the height of the COVID pandemic, Dr. Jones was performing emergency, often life-saving, complex orthopedic surgeries on Arizona residents, despite the non-compete that Education and HOPCO had. Skilled surgeons such as Dr. Jones are a resource for the state of Arizona, and that's particularly true today. I don't know if you've been reading about early retirements of experienced physicians that are just burnt out from providing patient care during COVID. So my position is the COVID-19 pandemic has served to heighten and emphasize and underscore the public policy concerns underlying the FARBR provision. Section 6.2 under FARBR is flatly overbroad. I don't care whether you consider it an employment-related, sale of business-related, something in the middle. I would contend that it's very similar to FARBR. FARBR also involved a one-third interest in a medical practice. This case involved the acquisition of a minority one-third interest in a medical practice. In FARBR, the trial court found that a 5-mile radius among 3 offices, which totaled 245 square miles, was overbroad, unreasonable. In this case, there are 29 locations in 2 states set forth in Exhibit 9. Each one of those had a radius of 314 square miles, if my math is right, 10 times 10 times 3.14. So
was there a liquidated damages or a termination payment equivalent in FARBR?
There was a liquidated damages clause in FARBR, and in that case, the Supreme Court didn't put the cart before the horse. The Supreme Court said the trial court was correct in determining that the underlying non-compete was unreasonably overbroad for a variety of reasons, and it didn't get to the liquidated damages clause in that case, which was 40% of gross billings by the departed physician for 3 years. So FARBR, from my perspective, is on all fours with this case in a number of ways. And I know Your Honors issued a minute entry asking that we discuss the Fierno case. The Fierno case, this is not Fierno. Fierno relied on a California decision. As you know, I know you've read the case, there's a split in terms of what ER 5.6 allows and doesn't allow. And the case that Fierno relied on in California said that the buyout provision did not expressly or completely prohibit attorneys from engaging in the practice of law. In the Fierno case, the court said, the Supreme Court, quote, the provisions do not restrict the right of the lawyer, do not restrict the lawyer's right to practice law after termination. What we have here in section 6.2, and it's right in the title of the provision, is a clause that says restriction on competition. And
in Fierno, there was a restriction, but the lawyer could get around it if he paid or forfeited his stock, isn't that? What was
at issue in Fierno was a buyout provision. There was no non-compete provision. It said if you chose, and it was ill-defined, it said if you compete in the practice area, then you return our stock and get nothing. That's nothing like the clause we have here. There is no buyout provision here. Dr. Jones still has his interest in HOPCO. And again, what the California court case relied on, what Fierno relied on, was there was not an express provision barring competition. And again, what we have here is section 6.2 that says restriction on competition. And then it goes on to say, in section B of 6.2, Dr. Jones shall not, ellipse, practice medicine in the restricted territory. That's pretty clear that we're talking about a non-compete provision that did bar him not just practicing orthopedic medicine, his
But
specialty.
he avoids that if he just pays back the money he got, or 4/5 of the money he got in the sale of the contract.
There's
part of
no,
business.
again, this is not a stock buyback provision, which is what the issue was.
All right, would it be any different if his, it's not an employment agreement, but the sale agreement had said, we'll pay you $350,000 in the form of $70,000 a year, but if you leave early, we're not going to pay you the remainder. Would that be different than this?
Yeah, there could have been a number of hypotheticals.
Would that one have been different? In other words, would they have to keep paying him the remainder of the $350,000 a year, or $350,000 over the course of 5 years, if he had left early?
Well, number one, what was tied to in this case was $300,000 was not anything that Dr. Jones got out of the deal.
Well, he got $349,000 out of the deal, right?
I believe so.
Okay.
So, yes, I think it would be different. I mean, what we have here, because I'll tell you
Why
why
would it be different?
It would be different because Section 6.2 says, or I'm sorry, Section 6.5 says, not only that if he leaves and goes to work for a competitor within whatever the geographic scope is, 1 to 10 miles, who knows, he's liable to pay under 6.5 $240,000 in liquidated damages now. He's also liable, according to Section 6.5, to pay actual damages that they prove. And Section 6.5 also says we can get an injunction, a preliminary injunction TRO, to enforce the non-compete restrictions in Section 6.2.
But did the latter two things happen? Did
They chose not to do that, but that doesn't impact the fact that Section 6.2 is overbroad and
But
unreasonable.
don't our cases say over and over again, in that case, anything that's overbroad and unreasonable, we blue line and then look at what is left to determine if it's unreasonable or not?
Sure, and that's correct. You can cut out grammatically severable provisions, but you cannot rewrite the provision. I'll tell you another reason why.
Okay,
Why
would
didn't it
this
just-
be, are those grammatically severable or not?
Is
The
which part?
provisions they're not seeking to enforce, that they're basically conceding are overbroad and unreasonable.
I would agree that, yes, I'm probably under 6.5, the provision that says we can get more than actual damages and an injunction could be grammatically severable, yes. So 6.2, why didn't he just pay the $240,000? I'll tell you why he didn't pay the $240,000.
That's a lot of money.
It's a lot of money. He also had a separate employment agreement with Education LLC that we sued for a declaratory judgment on that had a 10-mile, 1-year non-compete. He could have paid the $240,000 to HOPCO, and he'd still be restricted by the non-compete with Education LLC. There was also subsequent transactions in 2019 that led to a rollover agreement, a merger agreement that also contained non-compete restrictions. One of those non-compete restrictions barred him from practicing medicine nationwide. That's right now before the Delaware Chancery Court. So the fact that it was illusory that he could buy out of this contract, and
Why do those other agreements with other entities affect our decision here at all? I mean, I'm not arguing against that. I'm just not following why that
Sure.
matters.
I think when the courts consider non-competes, or they look at non-competes, they look at the totality of the circumstances. And this isn't a case where, we're using these other agreements to, get around the parole evidence rule and say that you should interpret the agreement this way. We're showing that the overall totality of the circumstances, that there were other restrictions, including an employment-related restriction that they threatened to sue on, that barred the same conduct. So he could pay $240,000 and literally get nothing out of it. And I'll flip the hypothetical around.
But you said the other one was a 1-year agreement?
Yes. And in the 2019 agreements, which are also in the record, were 3-year agreements, and they provided a number of things, including one that barred practice of medicine nationwide. I'll flip the hypothetical around. I mean, if the court in Farber, if they drafted the agreement in Farber and said, oh, you can pay, we estimate that your gross billings over the next 3 years are going to be $240,000, and if you want to leave, you got to pay that. That's not the approach. In order for a liquidated damages clause, which is what they call it, to be enforceable, there has to be an underlying breach of an enforceable contract provision. And again, under Farber, I don't see how this particular restriction in Section 6.2 is enforceable. I'll give you one reason why. Look at the geographic scope of the provision. There's 30 offices, and again, I mentioned each office has a 10-mile radius, 314 square miles, but that's not all. It also applies to facilities that not just HOPCO opens, but HOPCO's parents and subsidiaries, not just at the time of the agreement, but going forward. So Dr. Jones could have accepted a position of chief of orthopedic surgery at MD Anderson 1 year into the agreement, and then 2 months later, HOPCO opens a facility there. They send a demand letter and say, you owe $240,000. The fact that there's a buyout clause is not a get-out-of-jail-free clause for them to write an unreasonable, overbroad non-compete provision. And also under Farber, and this is the reason I mentioned the COVID-19 pandemic, because during the 3 months that Governor Ducey's executive order was in effect, all Dr. Jones did was provide emergency medicine, which was a violation of Section 6.2. Again, the fact that there's a liquidated damages clause, that's not a get-out-of-free card for them to draft and enforce an unreasonable non-compete provision on him. It's also not limited to his practice specialty. These are all things that Farber clearly says are required in order to have an enforceable non-compete. On its face, the restriction here is not limited to internal medicine or even pulmonology. It precludes any type of practice. Thus, we agree with the trial judge that the restriction is too broad. Emergency medicine, they affirm the trial court's ruling that the physician non-compete agreement was unreasonable, quote, because it did not expressly provide an exception for emergency medical treatment. So this is not a buyout provision. This is a liquidated damages clause tied to an unreasonably overbroad non-compete provision. I'll reserve the rest of my time.
Good morning, Your Honors. May it please the Court. This case is about a sale of a business and its goodwill. Under the sale agreement, HOPCO paid Dr. Jones just under $350,000 in exchange for his promise that for the 5 years after the sale closed, he would continue working at education or not compete against education. Dr. Jones agreed that if he left education early to join a competitor, he would pay back to HOPCO a portion of the consideration he received for his promises. In fact, to induce HOPCO into paying
What do you say to your colleague's argument that that was illusory because of the additional agreements in place that nonetheless would have prevented him from engaging in his trade?
The other agreements are completely separate, with separate parties, with separate consideration, and should be considered completely distinctly, and are being considered completely distinctly. In this case, the trial court has already dismissed those cases from consideration in this case.
And the trial court was wrong.
Sorry?
Just because the trial court did that doesn't mean we're obligated to do that. What about the totality of the circumstances argument?
Sure.
It doesn't apply?
The totality of the circumstances applies to the contract at issue.
And what does that mean?
It means, is the contract reasonable?
You're saying just the contract then, not those other
The
contracts?
provision at issue. That's correct. Yes. And with respect to the employment agreement, again, it's a separate agreement with a separate party. That's with education, separate considerations. And in this case, before the trial court, the education has already affirmed that it's not enforcing those covenants. So it's that consideration doesn't apply at all.
Talk to me about the Superior Court's brief ruling in this case. You heard our exchange earlier.
Sure.
I'd like to hear your thoughts on it.
Sure. As I think you mentioned, Judge Perkins, to reach a conclusion as to the enforceability of the shareholder termination provision, the shareholder termination payment provision, the court necessarily had to reach a conclusion about the reasonableness of the contract, and it did. The suggestion that there's discovery that wasn't allowed to happen before that was necessary is completely meritless. There was no request for Rule 56D relief saying that the Dr. Jones didn't have the opportunity to do discovery. That never happened. Instead, we have dueling motions for summary judgment where both sides acknowledge that the material facts were undisputed. So that's my response, is that the undisputed facts here were sufficient for the trial court to reach its conclusion, and it did.
Why doesn't Farber sort of change that conclusion, given, as your colleague pointed out, the similarities to this case and the lack of any findings on reasonableness or even findings on the facts that would lead us to a reasonableness conclusion?
Right. To start, Farber is entirely distinguishable, and it acknowledges as much in its own text. It notes that the sale of a business is an entirely separate world. The Gann case makes that point even clearer. It states that courts distinguish. Courts distinguish between covenants incidental to employment contracts and those incidental to the sale of a business because the policy considerations necessarily differ. And that's exactly what is happening here.
Does that apply, though, in the, and maybe I don't know as much about medical practice, but it seems like most medical practices, the doctor is maybe not most, but in many medical practices, the doctor is kind of an owner, oftentimes like lawyers are, that you have law firm mergers and you've got partners coming together and forming a practice together and then separating, et cetera. So isn't that the same in the medical world as well?
That's exactly right, and that is noted within the Farber decision. They talk about the comparison to lawyers, and they cite to ER 5.6 to say, look, with lawyers, you can't have a non-compete in an employment agreement. But 5.6 itself, ER 5.6 itself, has an explicit exclusion when lawyers are selling their law practice, which is what's happening here. Here you have doctors who are selling their their medical practice for $13.8 million of consideration. And if you take Dr. Jones's view of public policy, all 46 of the education shareholder doctors could pocket the whole $13.8 million they received for their promises, and then the day after the sale closed, they could quit education, walk across the street, and launch a competing practice, stripping Hopco of the entire goodwill that it purchased. That is not Arizona law. That is clearly unfair and would clearly undermine business in Arizona. This happens all the time. Doctors sell their medical practices just like lawyers sell their law practices. And a medical practice, the main value is the goodwill that it has, the intangible collective skill and reputation in the marketplace. That's what they're selling, right? They're not just selling their hours billed. They're selling the reputation they have in the marketplace. And as the Pace Industries case notes, if they're going to be able to do that, they have to be able to make contractually enforceable promises that they're not going to, the day after they pocket the money, walk across the street and bring all their customers over there, which is exactly what happened in this case. It's undisputed in this case that when Dr. Jones left, his customers followed, his patients followed. And under the sale agreement, that's fine. The sale agreement authorized Dr.
Jones. It actually wasn't fine. You guys just chose not to enforce parts of the sale agreement.
Well, let me be more specific. Contrary to what opposing counsel has suggested, the shareholder termination payment has two separate functions under the sale agreement. On the one hand, it operates as an option for performance, a pre-breach option for performance. On the other hand, if a breach happens, it operates as a measure of liquidated damages. But those are distinct. And here, the sale agreement authorized Dr. Jones to immediately quit after the sale closed and go join a competitor so long as he fulfilled his end of the bargain, which was to pay the shareholder termination payment. He had the opportunity to avoid all post-termination covenants by either staying for the 5 years, the 5-year post-closing period on which the $13.8 million was based, Or he could just pay the shareholder termination payment before he left. And he could go anywhere and do anything. And that is a material distinction from what happened in the Farber case. And that is similar to what happened in Fear Now, which Your Honors requested that we discuss. The Fear Now case highlights the importance of the option to pay money in lieu of non-compete. There, the judge found, the court found that because he had the option to pay money, the lawyer wasn't restricted to practice. He was just given less money if he chose to compete. That's exactly what we have here. Dr. Jones was not restricted from practicing medicine anywhere, anytime. He just got less money if he chose to do so. And to have public policy to the contrary would entirely upset how sales of business work in Arizona, including the sellers like education, medical practices who want to be able to sell their goodwill. It would never happen. No one would buy a medical practice.
Structure your deals going forward that's paid out in 1/5 every year for the next 5 years instead of an upfront payment.
Sure. I don't think that changes the reasonableness of the clause as it stands.
But, I mean, you're painting a little bit of a, this will be the end of the world as we know it type scenario. And I'm like, once people know the rules, they contract accordingly, and
Sure.
it wouldn't necessarily stop all sale of medical practices going forward.
Sure. And I think what's material here is that the clause as written is reasonable. It allows Dr. Jones options. He had the choice, which he exercised, to leave before the end of the 5-year period and go compete. All that the trial court's judgment does is ask him to fulfill his end of the bargain, to pay the amount he promised to pay. And remember, this is not the employment law situation where you have unequal bargaining power, where you have unrepresented employees, where there's no consideration for the promise other than just getting to work. None of that is true here. The considerations are entirely different. Here, $13.8 million was exchanged. With respect to Dr. Jones, he received $350,000 for what? For the promises he made. And upholding those promises is exactly what Arizona law requires. If we turn to the reasonableness of the specific covenants themselves, he talked a lot about those. As we've mentioned in our brief, that's not the contractual choices he made. He opted to immediately go compete, and that's his right so long as he makes a payment.
Do you acknowledge that our case law suggests or states that even in the context of a business sale agreement, we still have to look at the covenants for reasonableness?
Sure, absolutely. And the Gann case makes that point. The Gann case establishes that in the sale of business context, a covenant is reasonable so long as it's limited in time and space and does not require in this case, the doctor to refrain from all business whatsoever. And it's undisputed that that's true here.
How can we on this record then affirm the Superior Court's decision that this was reasonable when it seems like it's a pretty extensive scope, as your opponent pointed out. When you look at this 10-mile radius, it almost covers at least covers the entire state, or nearly the entire state.
Yeah, and I'll argue that the precise restrictions are immaterial, but what I will say is
How can they be immaterial?
Well, let me explain why. What is clear is that there is a 10-mile radius from the locations. That's correct. And in the sale of business context, geographic restrictions are reasonable if they match the geographic scope where the business operates. And that is exactly true here. It is undisputed that the businesses operate within the scope that they identified in the agreement. There's no controverting evidence to the contrary. That is undisputed. And as far as scope, you have the Gann case that in the sale of business context found that a restriction that covered the entire city of Tucson plus 100-mile radius beyond was reasonable because the parties were sophisticated and this is what they agreed to. Right? This is not the situation with an employee who doesn't know what they're doing. These are parties negotiating for consideration. And here, sophisticated parties negotiating at arm's length decided that it was reasonable to match the geographic scope of the business's operations to what was listed in the employment agreement.
So how much does the fact that it's just a financial penalty or recoupment of the investment factor into our reasonableness of the geographic scope analysis? Because that seems to be what you're arguing, and what is your support for that position?
The opportunity to pay the shareholder termination payment in lieu of any restrictive covenants is a key feature of the reasonableness here. And the reason why is because when you consider it, there didn't need to be any post-termination restrictions. If he had stayed for the 5-year post-closing period that the payment was based on, there would be no post-termination restrictive covenants. There would be none. But in fact, if we look at the clause today, the sale closed on January 1, 2019. There is 1 year left, less than 1 year left under the post-closing period. So there is 1 year left of this clause now. When he left, there was 4 years left. There weren't 5, there were 4. This is not a traditional non-compete clause that starts when you leave employment. This started when the sale closed. Why? Because that's what the purchase price was based on. They calculated the purchase price by projecting the future earnings that the 46 shareholder doctors would generate during 5 years after the sale, and they paid that money up front. But they paid it up front in exchange for the promises that if folks left early, they would give back a portion of that to compensate Hopco for what the contract specifically and expressly defines as an adverse change in the deal. And so again, the choice to avoid the non-compete altogether is a defining part of what makes this clause reasonable, what makes the contract reasonable as a whole. Sorry, okay. So as far as the geographic scope of the contract, we have examples under Arizona law of similar scope. And there's no dispute that these are areas where the business operates and that the restrictive covenant matches that area. And that's all that's required to show reasonableness in the sale of business context. With respect to the temporal scope, we've talked about that. It specifically matches the amount paid, right, the time period that they were paying for. And the clause is reduced every year depending on how long the doctor stays.
With regard to your comments about the record establishing the scope of the business as matching that 10-mile radius, can you remind me where that is?
Yeah, that is at our appendix, I think it is, 3 through 7 in the Declaration of Simon Willman. He makes that in paragraph 17. And that's uncontroverted. And again, as far as the activities restricted that opposing counsel discussed at length, here, as in the Fearnow case, the Fearnow case held that it's not restricting the practice, it's just giving the person less money if they make certain choices. That's exactly what happened here. And that makes this clause reasonable. Again, there are multiple contractual options that Dr. Jones could choose to avoid all restricted covenants. He chose to exercise his right to leave before the end of the post-closing period and immediately go compete, and that is fine. He just needs to fulfill his end of the bargain. And again, fortunately for buyers and sellers, Arizona public policy strongly supports enforcement of contractual mechanisms protecting the transfer of goodwill when a business is sold. That's in GAN. Farber acknowledges that exact thing. Protecting buyers' investment in goodwill factors heavily into the reasonableness analysis. And it's been consistently cited by Arizona courts as a primary reason weighing in favor of enforcing sale of business non-competes. That's exactly what happened here. Here, Dr. Jones elected to sell his goodwill. He didn't have to. He elected to sell his goodwill, and public policy weighs heavily against giving back to Dr. Jones that which he chose to sell. I'm happy to answer any other questions that you have. If not, I'll sit down.
Thank you, counsel.
All right, thank you.
Four minutes left. The Farber case. The Farber case involves sophisticated parties. The Farber case involved represented parties. In fact, the party that initiated the new employment agreement and buyout agreement was Dr. Farber. Nonetheless, the Arizona Supreme Court said, you have to draft a reasonable provision in order for it to be enforced. Section 6.2 is not reasonable. He says it matches the geographic scope. It doesn't match the geographic scope where Dr. Jones practiced. It includes a state he's not even licensed in. And not only that, it includes every location that HOPCO opens or operates out of anywhere in the country over the 5-year term of the employment agreement going forward.
Where do I find this dispute of fact in the record? That you disputed the scope of business?
Oh, sure, that's in our opening brief where we talk about the geographic
In the
scope.
factual record, if you could point me to where you presented evidence. Was it in your statement of facts or the
Yeah, it's in our,
statement of facts?
I believe it's both in our statement of facts and our controverting statement of facts, talking about Dr. Jones not being licensed in Michigan during the relevant time period, and talking about the fact that the 10-mile radius includes a huge amount of area. So it's not tied to where they're practicing. And again, to go back to my hypothetical.
I'm sorry, I was imprecise in my question. As I understand it, what your colleague pointed out was that the evidence in the record below pointed out that the 10-mile scope was related to the scope of their facilities.
Sure.
Do you have something contradicting that, or was the evidence that you just pointed me to just that it was very large and impacted Dr. Jones's ability to practice?
Yeah, two things. Exhibit F listed the existing locations, and it's very large. That's in the record. The agreement says, and it can't be blue penciled out of it, that it covers every area where they have a facility or where they do any business. So if they opened up new businesses or new facilities, using my Arthur Anderson example, there's no protectable interest there. And again, this was not a sale of a business. This was a purchase of a minority interest in a physician practice. In terms of the example of the 48 physicians leaving and taking the goodwill, why would they do that? They own 2/3 of the goodwill. They would be destroying the practice that they're owners of. It's not a traditional sale of business case. And going back to public policy, if you look at the FTC rule that's in the news regarding non-competes, and who knows if it'll go in effect or if it's legally challenged, they do have an exception for sale of business, but it has to involve the sale of all or substantially all of the assets. And again, functionally, this is equivalent to the Farber case. I mean, the Court of Appeals in Farber said, the valuation of the business on which a buyout price is based generally would include goodwill value that would be compromised if the physician who leaves takes the patients from the practice. It's the same consideration in Farber that we have here. And not only that, what this really is, and I probably don't have like 50 seconds to go, this is a penalty. Do any of those damages occur if he retires? I mean, what he said was the projection assumed each of the physician shareholders would be
If he
made.
retired, he presumably wouldn't be taking the clients with him.
Yeah, but he's not. He's an emergency orthopedic surgeon that only works in level 1 trauma centers. The majority of his practice is emergency medicine. In terms of the patient follow-up care.
Your opponent said that it was undisputed that when he left, he took his clients with him.
Yeah, what we said is there's a patient interest in that. Sometimes Dr. Jones will have to do 25 surgeries on a patient. If you're in a motorcycle accident with a lot of damage, would you want to have a new surgeon do surgery number 10 or 11 after having 9? So that's all we're saying. You didn't solicit outpatients.
I guess it would depend on how the first 9 went.
Yeah, exactly. So I have 3 seconds left. Thank you for your time. I'll entertain any more questions if you want to go over.
Thank you, counsel,
All right,
for your
thank you.
arguments. We will take the matter under advisement and issue our decision in due course. We'll be in recess for resetting.
Can we get cups? Yeah. Okay, thank you.